Good afternoon, everyone. Let's get started. We have a lot to cover in the next 1 hour. My name is Leila Nourakish, and I'm a Senior Policy Analyst for the Information Technology and Innovation Foundation in Washington, D.C. On behalf of ITIF, I would like to welcome you all to today's panel on the DOJ's Google AdTech decision. Did the court get it right? As a brief background, last month, Judge Brinkema in the District Court for the Eastern District of Virginia issued a landmark decision in the Department of Justice AdTech antitrust lawsuit against Google. The court found that Google monopolized the ad exchange market, connecting publishers and advertisers, where Google offers its edX product, and the separate ad server market, where Google offers its DoubleClick for Publishers solution that helps publishers manage their ad inventories. Judge Brinkema rejected parts of the DOJ's case, including claims that Google monopolized the buy-side ad network market and that its acquisition of DoubleClick and AdMelt were anti-competitive. On the other hand, Judge Brinkema found that Google engaged in anti-competitive conduct, most notably unlawfully tying by conditioning real-time access to its ad exchange on the use of its DFP ad server without sufficient pro-competitive justifications. On the top of this, just a few weeks ago, the DOJ put forward a series of proposed remedies to address Google's behavior, which include breaking up Google by forcing it to divest its edX and DFP offerings. We are fortunate to have a great group of antitrust experts here with us today to discuss the FTC's case. Now, I would like to briefly introduce our panelists. First, Caitlin Bradish, Vice President and Director of Legal Advocacy at the American Antitrust Institute. Previously, Caitlin served in government, including as Assistant Chief and International Counsel at the U.S. Department of Justice Antitrust Division, in addition to having a distinguished career in private practice at Cleary Gottlieb in D.C. Caitlin, glad to have you back at ITIF.
Thanks so much.
Second, Eric Hubenkamp, Professor of Law at Cornell Law School. Eric is both an economist and a leading scholar in antitrust law and economics, and has several award-winning articles in the areas of antitrust, intellectual property, economics, and more. He is also a fellow at Thurman Arnold Project and Information Society Project at Yale. Eric, thank you very much for joining us. Third, John Young. John is an associate professor of law at George Mason University's Scalia Law School, specializing in antitrust economics, intellectual property, data, and privacy. A leading figure in the field, John previously served as acting deputy assistant director in the FTC's Bureau of Economics, where he worked for nearly 2 decades. John, great to see you again.
Thank you, Lola. Great to be here.
Finally, Joseph Coniglio, Director of Antitrust and Innovation Policy and the Schumpeter Project on Competition Policy here at ITIF. Joseph is a top antitrust policy thinker who has published numerous pieces of antitrust and tech issues and is regularly quoted in top media like Reuters, Wall Street Journal, and Washington Post. Before joining ITIF, Joe worked as an antitrust attorney at 2 leading international law firms, where he focused on unilateral conduct and merger enforcement. Welcome to all our panelists. Here, I would like to encourage our audience to submit their questions or Slido. Now, without further ado, let's start our conversation. So, Caitlin, I would like to begin with you on the findings that Google has monopoly power in the exchange and ad server markets. Did the court properly define the relevant markets and find that Google is a monopolist?
So short answer, yes. But I think to back up, I think market definition really is the largest part of Judge Brinkema's decision here. It really is the focus of much of her analysis. And a huge portion of her opinion focuses on the facts around market definition. And in particular, whether that the market definition here is constrained by the dictates of the Supreme Court ruling in Ohio versus Amex, which defined two-sided markets. So in a nutshell, Judge Brinkema found for the DOJ on 2 of its 3 proposed markets. just to put it quite roughly and simply, she agreed that there was a market for open web display ads on the publisher side. Think New York Times or other websites that are selling space. Those are the customers here. And for the ad exchange, where the actual ad auction happens, but did not find for DOJ on the advertiser side. Think US Census Bureau, who is a witness here, or anyone, basically anyone with a product to sell that wants to advertise on the internet. So I think here there are two real questions. Should this have been a single two-sided market, as Google argued, or not? And second, is there a distinction justifying the open web display ad narrowing on the publisher side, but not on the advertiser side? So I'll take I think the easier question first, the open web display question. Here, Judge Brinkema concludes that while advertisers may have substitutes for open web display ads, including ads on walled gardens like Meta, Facebook, or Instagram, and other in-app options, for example, that this does not apply on the publisher side. Publishers like the New York Times can't necessarily go to its app or to social media to meet the demands that for it to make money from selling its ad space. So this makes a lot of sense to me. I can't, obviously Judge Brinkema has the full set of facts. She goes into great detail about this question, but it does seem like just from an intuitive standpoint, the New York Times has to sell space on its website. It can't shift all of its efforts to just its application, can't run auctions on its own. And this is even more prominent when you're talking about smaller publishers, someone not like the New York Times, but someone with a lot less resources than the New York Times. I think the second and more complicated question is the question of whether this is all one market for ad tech services, or if it's three separate markets, as Judge Brinkema concluded. Judge Brinkema, I think, realized that this is the key question here, and she devotes a full 10 pages of her opinion. It's a 115-page opinion, but 10 pages of it are solely dedicated to this one question. So Judge Brinkema concludes that this is not like Ohio versus Amex. And in short, distinct products should not be grouped into a single omnibus market simply because they work together to achieve the same overarching purpose. This is her conclusion. So in order to get there, she draws an explicit contrast with the credit card market in Ohio versus Amex. She points out that a product is not part of a two-sided transaction platform just because it helps one side improve its capacity to transact. She actually uses the credit card market to illustrate this. She points to checking accounts, bill splitting apps, etc. And she notes, well, these all facilitate potentially credit card transactions, but they're not part of the credit card transaction market. And she also limits the Amex decision to instances in which a sell-side transaction cannot occur without a simultaneous buy-side transaction. She notes that this is maybe true of the ad exchange, the actual platform where the ad auctions happen, but not of the whole overarching system. So her evidence, which I think is quite compelling, is that products that, she writes, products that serve economic actors on one side of the industry and can be sustainably sold by firms that specialize only in that side of the industry are to be analyzed in markets that consist of reasonably interchangeable products on that side of the industry. So buy side, sell side. She notes there are products being offered only for buy side, products being offered only for sell side, and that this is a good indicia that it's not one market, but several markets. And I think this is not, I think, the core of her decision-making, But she does note that Google, in fact, advanced a one-sided market in another previous case at the motion to dismiss stage. So she does take that as an indication that even Google agrees, at least at some point, that there is not just one cohesive market, but in fact, separate markets at issue here. So on the monopoly power question here, I think this is a very traditional analysis. She looks at market share, she looks at high barriers to entry, and then she looks at potential direct effects. So on this, the evidence, I think, is what you would find in most monopolization cases. She finds that the market shares are quite high, 91% in the case of the publisher's side product, 50 to 70% in the case of the ad exchange itself. And she goes along with several pieces of evidence, including industry perception that Google has a dominant position in its areas. On the publisher side, the stickiness of the publishers, the fact that they didn't switch even though the quality of the product degraded, even though they kind of wanted to switch, or there were indications that they would have wanted to switch. And she also looks at the failure of alternatives. She points specifically to Meta's attempt to get into this space and the fact that it was not able to do so. In the ad exchange, she looks mostly at the take rates and points to evidence that the take rates were super competitive, that they lasted. There were internal documents saying that that the take rates were awfully high to last this long, that maybe they weren't justified. And she finds that durable take rates that seem to be not in line with what a competitive price would be, continued without being undermined by competition. So
thank you, Caitlin. Joe, do you agree?
Thank you, Leela. I want to really hit down on the two issues that Kathleen raised, because I do think they are really critical, into how this case was decided the way it was. So first, on the open web display market definition question, I certainly agree with Kathleen that there certainly could be some publishers for which some of these exclusions make sense. Certain publishers that may not have a mobile app that they can use to get ads. Certain publishers that need to rely on open exchanges as opposed to, let's say, the closed ecosystems, the walled garden ecosystems like Amazon and Facebook. But I think the problem here is that these terms, these exclusions were used generally, for all publishers, without any attempt to identify targeted groups, right, for which these exclusions may have been relevant, right? So maybe some publishers, again, needed the web the advertising channel much more so the mobile app, but maybe they could have used, right, Amazon or Facebook, right? So I mean, I think those are the types of questions that were nuanced, and the general exclusion of all of that traffic doesn't make sense to me. I mean, just to give one data point, I think it was in 2022, 55% of display ad spend was on mobile apps, right? So it seems very, I think, unrealistic to just sort of exclude that from the market in a general way. So I think that's the first point, and I think issue that I would take with the market definition. The second point is, again, to the issue of whether Google, the ad tech suite, should be looked at as a platform. And, I agree with Kathleen, this is a very complicated question. I think Judge Brinkema did her best to grapple with, again, the nuances here. But I think I would say, just looking at sort of the key three factors that the Amex court identified as to when you should sort of apply this transaction platform analysis. You have the question of whether or not the market is two-sided. Are you connecting to just separate groups to eliminate transaction costs? Or is there a simultaneous transaction that's being facilitated? And then number three, do you have network effects that obtain across the platform? Specifically, the more people on one side that there are of the platform, the more valuable it is to the other. And I think at a very high level, and even into the details that the judge discussed, there's a lot of evidence for thinking that those three conditions apply here. I think that the Google ad manager suite is absolutely, the core purpose of it is to connect advertisers and publishers, and that there are clearly network effects that obtain on the platform, right? The larger Google's ad demand network is, the more valuable it's going to be to publishers and vice versa. And again, the point of it is to facilitate these simultaneous transactions. And even though it's true there is additional functionality that these products can provide, I don't think that should come at the expense of defining a transaction platform necessarily. So again, I think there is some good evidence for a transaction platform here. And I also think the categorical exclusion of closed ecosystems, non-web ads, and non-display ads, especially video, wasn't justified as a general matter.
Thank you, Joe, for your remarks. Eric, please continue the discussion.
Yeah, so I agree with much of what Kathleen and much of what Joe said. I think this is a really messy industry, and I think it's inevitable that market definition is going to be unsatisfying in this case. There was really no way to avoid that. I think I tend to think that that the district court came out with probably the best set of answers on this. Although I still think it's not entirely satisfying. Let me just limit my comments to this question of whether we should just regard the entire ad tech stack as one two-sided platform. So I think that would be a mistake, because Google is, really the only major player operating at all three of these different levels, right? So if we were to regard this entire stack as one market, then, we would be regarding these three separate stages: the ad publisher, ad servers, the exchange, and the advertiser tools on the other end as all different parts of one sort of two-sided entity. But again, almost all other firms in the area just operate at one of those stages, right? So I'm not sure that it would make sense to regard this whole thing as just one big two-sided market. I think it's a really complicated two-sided market where we've got an ad exchange in the middle, which is a two-sided platform. And then we've developed these sort of complementary entities on each side that are designed to help each group, advertisers and publishers, to sort of work through the two-sided exchange more efficiently. But I would regard each of those complementary businesses as largely one-sided. The analogy I would give is it's sort of like a marketing firm that's going to help you, for the publishers at least, it's a marketing firm that's going to help you decide what ads you want to run, but it's not going to connect you directly to consumers. It's just going to help you to design your strategy better, right? So that's sort of how I'm thinking of it.
Thank you, Eric. That's a food for thought here. John, the floor is yours.
Thank you. And I have the advantage of hearing the thoughtful responses of the other panelists, which I really appreciate. So I'll talk about Amex as well, because I do think that's the most interesting, at least for me, partly because a lot of the details are very complicated and hard to unpack. So in terms of Amex itself, I know it's a controversial decision. I think it was 2018 it was decided, and since that time there's been a lot of predictions about the doom of tech cases based off of that has not turned out to be true. And I think Amex is a good case, and obviously there's dispute over that. And the question, though, is, and obviously relevant here, is the scope of its decision and its applicability to new sets of facts. And I think that's obviously the key question here. So on that question, my position is largely the same as Eric's. Given the theory of harm, which I interpreted as sort of this supersized self-preferencing technological tie between AdX and DoubleClick for publishers. And these represent sort of different types of technologies aiming to do different things and how they integrate with each other. The theories were based primarily on giving Google sort of an unfair position and advantage in the exchange and who gets that right. And so on that dimension, I felt like the relevant market was appropriate of limiting it to sort of the tools for publishers and the tools for the exchange itself. And so on that dimension, that doesn't mean that Joe's points are not relevant. They're quite relevant. The question is how do we bring in the network effects and the integration? And that obviously should form part of the analysis. But in terms of the actual definition, I felt like it was adequate to get the job done. And for reasons that one Eric mentioned is this sort of this large omnibus market bringing together different packages of software that different types of entities use felt very different from Amex. And I thought it was a leap that asking a judge to make is a difficult one, even if maybe there's technically some good arguments to be made there. So I think that's reason one. I think reason two, Amex is strongest when it's sort of directly on a governance decision that a platform makes that affects sort of both sides. I think that's good economics. When we look at the profit maximization of a platform like Amex and they put in a non-steering rule, how does this affect merchants and cardholders and the adoption of the network and its growth and free riding? I thought the court was right to say, hey, we have to look at both sides and the welfare impact before we assess anti-competitive harm. In this case, I didn't see that same element of sort of a governance decision made by, let's say, AdX to implement a certain feature that affects the two sides in different ways. This was integration of two sort of software packages, if you will, in different ways. And I thought there it tipped in favor of not bringing in an Amex. So it's not that I disagree with all the comments. I just felt like practically it made the most sense. At least that's my initial read. I could be convinced otherwise.
Thank you, John. Indeed, this is a very complex case, and you all highlighted the most vital aspects of the monopolization and the relevant markets. Now it's time to turn to our second question for today, whether Google engaged in anti-competitive conduct. And Joe, I would like to begin with you. As noted, Judge Brinkema found that Google engaged in unlawful tying by restricting real-time access to its AdX to DFP. Did Judge Brinkema evaluate this claim correctly?
Sure, thanks, Leila. So this was a big debate in the case, obviously. The DOJ saw this as basically contractual tying of the kind that you would bring under Section 1 of the Sherman Act. Think, if you want my peanut butter, consumer, you need to buy my jelly sort of thing. Google had a very different view. They saw this basically as a horizontal refusal to deal under Section 2 of the Sherman Act, in which case the Trinco case would have applied, and it would have been very tough for the DOJ to win. And Judge Brinkema ultimately went with the DOJ's view, saying that this was Section 1 tying, and applied a much lighter test, a modified per se rule, effectively to condemn Google's behavior, and at the same time found that protected, maintained its ad server monopoly. And I think that was a mistake. So unlike contractual tying, there really is, our standard contractual tying, conditional refusals to deal to consumers, there is a real element here of a refusal to deal with a competitor like Trinco. And the other thing I would point out is under the Section 1 tying test, you need to show that there are separate products. So even if you agree with the idea that AdX and DFP are separate products, real-time access to AdX, I don't think is quite a separate product in the same way. It's much more, it's a design decision that Google's making. And in fact, this is exactly how the Microsoft court a couple decades ago treated this sort of behavior. They are Microsoft's design decisions to make OS very difficult to interoperate with Netscape, rival browsers. And what the court said is, I think what Judge Brinkema should have said here, that the separate products test really doesn't apply to this behavior, and Section 1 tying law isn't applicable. And instead, we should apply a rule of reason test that basically balances the harms and the benefits, if you don't want to apply the Trinco standard. So, and of course, one of the big problems with not applying that sort of test is you don't have to show any competitive harm, when you apply a modified per se rule to tying, only market power in the tying product market, separate products, et cetera. Judge Brinkema did evaluate whether there was any pro-competitive justifications for the AdX DFP integration. And she said there weren't, but I think that too was a bit of an error. I think there's clearly rationales that Google has for wanting to, protect, have a secure ad exchange, and how that could be affected by, opening it up to rival ad servers. And also just, again, the free riding justification, right? I mean, Google competes with these other ad servers, and it doesn't want them free riding off the investments it's making in AdX. So I do think Judge Brinkema could have looked at this one a little differently, either, if not the Trinco refusal to deal, certainly under the Microsoft standard, but she did neither.
Thank you, Joe. Eric, how do you see the tying claim?
Yeah, so it's interesting. So I think that both here and in the Section 2 analysis, the court could have done a better job of sort of clarifying like what practices like affect which antitrust claims. I'll get more into that in the second part, but there's a part in the opinion where the court says, well, actually the tie violated both Section 1 and Section 2. Okay, so I think that's really important because, as Joe said, the Section 1 requires an agreement, and it doesn't really seem like there was an agreement behind this tie. It seems like it was unilateral. Basically, AdX won't send real-time bids to anyone other than DFP, right? So that sounds unilateral to me. It seems to me like arguably there could not be Section 1 liability for that, which would take away the Section 1 tying claim. But I think that the tie, or like just as an economic matter, was really the biggest part of the case. And so like in terms of conduct. And so like even in the Section 2 claims, this refusal to let AdX send bids to rival ad servers was like a really important part of the case. And I think that the court was right not to apply Trinco to that, right? Because one thing I've written on is that there are a lot of like refusals to deal that are sort of economically indistinguishable from tying, right? And sort of to treat them as like as if they fall under Aspen would be sort of like formalistic line drawing to some extent, right? So I think here it's clear that Google is, trying to use it's leveraging AdX to try to gain an advantage in the separate market for ad servers, publisher ad servers. That's the theory of harm in a tying case. And so I think that's, that it was right for the court to treat this essentially as a tie, even for Section 2 purposes. In terms of the free riding argument, we could have made the same argument in Microsoft, right? We could have said like Netscape competes with Microsoft and Microsoft shouldn't have to let them use Windows, right? Because it invested a lot in Windows, so it should be able to exclude its competitors from using it, right? So that argument didn't fly there. I don't think it should fly here. I think when it comes to a tying-like claim, like the underlying, like the implicit premise is like you're allowed to have your monopoly in the tying market. You're just not allowed to use that to like interfere with competition in a separate market, right? And so I think that's what's happening here. That's what happened in Microsoft, right? Like it's okay that you're dominant in AdX, but don't use that dominance to try to impair competition in this separate market. So I think that that much was okay, but I do think there are other problems with the court's analysis of the tying claim.
Thank you, Eric, for your evaluation. John, I would like to give the word to you.
Thank you, Lila. So I won't go further on the tying itself claim. One is because I'm an economist. Economically, I felt like it works the same thing as a tie, whether it's legally one or not. I'll defer to my colleagues here and the fellow panelists who I think would have better insights on that. But I did want to comment on the larger duty to deal doctrine and the characterization of the doctrine by the court. Again, I agree with Eric that it probably shouldn't have applied. I see it more as a tying claim than a refusal to deal. But even if, however I view that, one of the things that concerned me is that the court made a distinction, sort of referring to the Fourth Circuit's Duke Energy decision, that there's a difference between the duty to deal doctrine when we're talking about a regulated versus unregulated market. And I know that others have written about this and they have said this is what Trinco should have been, or we want Trinco to be. But I think that's a different line of argument to saying that's what Trinco is. And I think that's what the Fourth Circuit did in Duke Energy. I think Judge Brinkema, to be fair, was just following that precedent. And this was a part of her decision, not the only part. So I don't want to overemphasize this. But I think it is fundamentally a misreading of Trinco to say that it created two buckets, an unregulated bucket and a regulated bucket. And so I come to this conclusion for two reasons. The first reason is that the court was explicit in bringing together Aspen skiing and Trinco to create a unified boundaries of the duty to deal doctrine. And as we know, one is regulated as one is unregulated. So it doesn't sort of stand to logic why they would do that if they created two sort of buckets for the doctrine. Number two, they did mention the importance of assessing the regulatory nature of an industry. Of course, that's in Trinco because obviously telecom is heavily regulated. But they did it in the context of understanding a market in terms of its competitive effects and understanding the sort of the scope of the remedies needed to ameliorate any sort of anti-competitive harm. But the context of the duty to deal application was whether or not Verizon had a sort of layer of, beyond the regulation, a duty to deal from antitrust law. That's what the court was trying to answer. And there it related to aspen skiing and unregulated markets. So I think it's not only just a strain, but I really do think it's a misreading of Trinco to try to create these two buckets. I think that's what the Fourth Circuit did in Duke Energy. I think that'll be interesting how far that goes. Maybe the Fourth Circuit will clean that up. Maybe they'll double down. But at least that was my reading. Again, I don't want to overstep my economist bounds. This is clearly sort of on doctrine, but I just can't read it any other way using sort of just my logic.
Thank you, John, for those very balanced reflections. Caitlin, now all eyes are on you.
Thank you. So I think it's important to understand, to see the opinion as having several different layers of theories of anti-competitive harm, and rather than distinct pieces. And I think much of this has to do with the Duke Energy case and the fact that the Fourth Circuit has said that you need to look at monopolization claims in particular as from a holistic perspective and not necessarily break it up into tiny pieces of conduct. So I think one can focus on a particular issue like the agreement question on Section 1 or refusal to deal regulation, but I think it's important to look at the whole picture in which each of these kinds of overlaps with one another and creates a clear picture of monopolization. So with that, I think I'll just mention, since I think everyone has covered a lot of the specific details, first on the refusal to deal question, I don't think that Judge Brinkema makes it turn on whether this is a regulated industry or not. She mentions regulation, she talks about regulation, but I think in her decision, it only plays the role of context matters. Trinco took place and was discussing a regulated industry. We have to consider the fact that this is not a regulated industry, and therefore we may not apply things the same way. And in fact, she does look at all the reasons that are discussed in Trinco for why you might have concerns about refusal to deal, and talks through each one of those in order to describe why that isn't a concern here. So that it's not, and she notes that there's a sacrifice of short-term benefits, which would actually put it in the exception that Trinco created. So I think as a whole, we can't necessarily lose the forest. We can't lose the forest for the trees, and we have to take a look at the whole picture of her opinion.
Thank you, Caitlin. Now I would like to navigate us to our third subtopic for today. Eric, I would like to discuss Google's other behavior that was found to be anti-competitive that factors into the attacks monopolization claim, such as Google's first look and last look policies, as well as its uniform pricing rules. What do you make of Judge Brinkema's opinion in this regard?
Yeah, so what do I think? So I think that the court talks about this long list of practices that Google does other than the tying, right? Like first look, last look, unified pricing. And I do think that most of those things were, I think, anti-competitive or were sort of reinforcing other potentially anti-competitive practices. But I think that what we're sort of missing from the opinion is like sort of mapping those practices onto the monopolization claims a little bit more clearly, right? So like she doesn't really delineate between, she finds monopolization in two different markets and really doesn't delineate between them very clearly in the opinion. She doesn't say like these practices achieved monopolization in this market and these ones achieved it over there. So I think that there is some vulnerability on appeal potentially that that there's not a clear sort of causal hook between the practices that she's alleging and the monopolistic effects. I do think that, you know, like the first look, which was this practice in the original, back in the early days of this industry, where Google would always get the first chance to satisfy a publisher. You know, that was something that was going to clearly give Google an advantage. Last look is similar. It's under the more modern system. It ensures that all the other ad exchanges place bids at the same time, and then Google gets to look and see if it can beat it, right? So it gets that sort of privileged position that too, I think, is going to sort of distort competition in Google's favor. So I think, you know, I think this long list of anti-competitive practices is, for me, part of the reason that this seems like a strong case to me, that it's not just this tie, that there's a lot of these other practices going on. I did not really think that Google was offering very compelling efficiency justifications for them. But again, I think that the opinion is lacking a little bit in sort of telling a cohesive story that sort of puts all of these practices together and explains exactly sort of how they caused you know, the requisite anti-competitive effects in the markets the court identified.
Thank you, Eric, for your thoughts. John, how does the economist see this?
So, in full disclosure, I'm not even going to pretend to understand the complexities of these markets. But the way that I read it, and I just read the opinion, and I didn't look through the expert reports and sort of the other sides here, but my position is largely the same as Eric's. It looked like the first look, last look, Project Poirot, the unified pricing rules, sort of, to use a baseball analogy, the other exchanges, you know, started the count with 0-0, no balls, no strikes, whereas Google had a couple balls already to start the at bat. It kind of felt that way. It tilted the competitive environment in a way where the ad exchange, AdX, would be the winner more often than not, not based off of the merits, but based off of the technical sort of advantages it had. At least that's how it read to me, and it felt, at least on its surface, to be plausible as something that was sort of made a deficient competitive process. That being said, I do have some criticisms of the decision and how it characterized it, and largely based on the mechanism of how this hurt competitors. So I do acknowledge that it gave Google a leg up, and that didn't seem quite on the merits, but the mechanism that everyone went through, both the DOJ and the court fully bought into, is this notion of denial of scale. And my problem with this argument isn't that it's illegitimate. It's just, it's milquetoast use. It gives us no information, because the way that DOJ and the FTC have been using scale, I just think is problematic. And I mean this broadly, because if you look at their recent complaints, and let me just go through the litany of them. DOJ versus Visa, 40 times scale is mentioned. DOJ search distribution, 36 times. This ad tech complaint, 71 times. The Amazon complaint by FTC, 76 times. FTC versus Meta, 24 times. The 2023 merger guidelines, obviously not a Section 2 or 1 case, but the merger guidelines have baked into this notion of scale. And my problem with this sort of, I think, abuse of the scale theory is, one, they don't define what scale they're talking about. So, and as economists, that's frustrating. There's minimum viable scale, there's economies of scale, there's minimum efficient scales, and there's data-driven data scale effects. None of those are clarified, and it's clear they're jumping from one to the other depending on the context. Two, it's a tautology. If you win business, whether on the merits or not, you deny scale or sales to your rival. It happens all the time. And so it tells us no information. So for this to be viable, it needs to be specific. So something like McQuain, where the agencies were very specific of the scale you need to be competitive. And I think it's legitimate. It's a legitimate theory. And so when we get to excuse me, remedies, and we don't have a sense of the scale necessary, then everything's on the table. Oh, they need more scale. Let's give them the entire package. Well, that seems a little unsatisfying because it's not falsifiable. If you are not clear about the scale you need to be competitive, and then we get to the remedy stage and we're like, okay, how much do you need? Well, I don't know, everything. It just feels like an exercise of a punitive exercise of you did something wrong and we're going to take away everything, and for scale reasons. I just find it dissatisfying. I think we should demand more of the agencies. I was a little troubled that the court was not critical of this argument, and I'm hoping maybe on appeal that this is something that's revisited, because I think this level of imprecision really shouldn't continue.
Thanks, John. Particularly interesting views on scale and, of course, the statistics on it. Caitlin, please continue the discussion.
Sure. So my initial point would be that I take your point about remedies and the need to look at how scale is defined in that context. However, I think it's important to remember that there will be a remedies portion of this trial where that will be the primary question. Is a particular remedy justified by the actual anti-competitive conduct? So I think we have yet to see what that will look like. What I would like to focus on in terms of the Judge Brinkema's analysis, what I find most compelling about her analysis here is on the pro-competitive analysis. Google offered a lot of theories about why these particular rules were beneficial and pro-competitive, and Judge Brinkema really went through each of them in great detail in order to show that these reasons were protectual. So there was discussion of whether this stopped spam or whether it made the platform more secure, et cetera, et cetera. We've seen these a lot in tech cases all over the place. But I think one of the victories of the DOJ case was really to take those supposed pro-competitive benefits apart with their witnesses, with their experts. They had witnesses, for example, that testified that there wasn't any less spam on the Google platform than there were on competing products. So I think that may be one of the places where the DOJ really did the best job and really earned what they got from Judge Brinkema.
Thank you, Caitlin, for your very interesting insights on this. Joe, please share your point.
Sure, I'll try and be quick. I think a lot of folks have already hit on some of the key issues, but I do want to say a couple things. So first, when you're talking about the ad exchange market and the monopolization claim there, as Eric, I think, already mentioned, this is a transaction platform applicable to Amex. And what that means is Judge Brinkema would have to show that these various practices resulted in harm to the platform as a whole, in the form of, let's say, reducing output, rather than just to one side of the platform. And, at least as I read the opinion, I really didn't see that analysis being conducted for the last look, the first look, the unified pricing rules. I just didn't see that evidence that the platform as a whole was harmed, as opposed to maybe certain groups of on one side, particularly publishers. But again, and on the pro-competitive justification side, Kathleen mentioned, I do think there were some pretty clear pro-competitive benefits here. I mean, I think a lot of these practices, at least one side of the platform had something that they benefited from, right? So first look, beating the waterfall bid, last look. I mean, this was designed to give publishers better bids, right? And the unified pricing rules, similarly, designed to basically prevent publishers from cheating by having different bids on different platforms, which I think plausibly would improve the platform overall. So, and just at a high level, I think it's worth stepping back on the pro-competitive justification side. I mean, if it's really true that Google had a monopoly here and it was excluding competition vigorously and there were no pro-competitive benefits for everything we're doing, I think that's kind of hard to square with just the rapid growth in the display ad spend in the United States, approximately 18 billion in 2008, to 137 billion in 2022. So again, a growing market, as well as one where Google's share has been steadily declining, right? So I just think those dynamics really aren't consistent with a company that's monopolizing and not acting with any pro-competitive justifications in the industry.
Thank you, Joe. Now we reach the final part of our panel discussion. Given that we have the DOJ's proposal on the remedies, I would like to ask first, John, what do you think about the DOJ's remedies proposal? And in particular, does the divestiture of AdX and DFP make any sense?
So I know we're butting against time, so I'll keep this relatively brief. So I don't think the DOJ's ask is appropriate, and it's not consistent with Judge Brinkema's actual findings, which is that the double-click acquisition and AdMeld, which went into the AdX exchange, the acquisitions in of themselves were not anti-competitive. It was just how they were implemented and integrated, obviously, what we've been talking about. And so I think that naturally lends itself to more of a behavioral conduct remedy rather than a structural one. And I know there's been criticisms about these types of remedies, and many have pointed that structural is the clean way to do it. Behavioral doesn't work. Divestiture studies are clear. And, I was at the FTC when these studies were done, and I'll do I'm old enough to remember line here. I'm old enough to remember a lot of things, unfortunately, but one of which is that I've seen these things fail both sides. I've seen structural remedies, this is going to be great. This is going to restore competition, completely burn out. Assets were eliminated and they exited the market. It was a disaster. And I've seen behavioral remedies work really well and work poorly. These are trade-offs. These are two tools. Why would we limit ourselves to say, now we have to go structural? Behavioral doesn't work. I don't think that's the reality of the divestiture studies. It's not the reality of sort of the boots on the ground of doing the actual agency work. So I'm really troubled by these arguments that I've been hearing, that structural is the only way to go and to ensure it. Otherwise, it's a judicial regulation. It's not judicial regulation. Regulation is very different. And I just think those arguments are being a little too simplistic. I'm not saying structural is inappropriate here. I just felt like, given the theories of harm, it's consistent with a behavioral. And if we did want to restore things, I don't know. I know this is controversial, but maybe give first look to, in a randomized way, to other ad exchanges to give them an advantage for a period of time, something like that if you need it. But I think the divestitures are a little too drastic.
Thank you, John. Eric, how do you see the remedies proposal?
I think I agree that I'm not a huge fan of breakups, right? So for me, a breakup is a remedy of last resort. And so there are a number of factors that I think are really important to consider. One of them is if you were comparing this to the Google search case, one of the things that really clearly cuts against a breakup there is the fact that that case is all about agreements, right? And so you can just enjoin the agreements, right? I think you would want to do more than that, but you can correct the anti-competitive behavior fairly easily with an injunction. One factor that might cut in the direction of breakup here is that a lot of the conduct is unilateral. So that it's more difficult to deal with. But to me, it's still not clear that a breakup is the only way to address these concerns, right? So I would like to see really concrete evidence for thinking that a divestiture was necessary before I would feel comfortable going in that direction.
Thank you, Eric. Now, Caitlin, the floor is yours.
Sure. So I don't want to prejudge this to a certain extent until we see the remedies part of the trial, because I think there will be evidence there that tells us more about whether structural behavioral makes the most sense. But I will say that with respect to the kind of harm here, that it is unilateral, that it is not the result of agreements. It is exactly the kind of problem that has been identified with behavioral remedies, which is informational asymmetry. Google will always have a lot more information about how it's doing its processing than any external monitor, than anyone outside of Google. So to have a behavioral remedy that depends on how Google is running its business, particularly in a high-tech area where a lot of external observers aren't going to understand how it's happening. I think that's problematic and decreases the probability that a behavioral remedy will be effective. And I think that absolutely has to be part of the calculus. The other part of the calculus I think is very important for remedies is what will actually restore competition here. In that respect, I think it matters how long this conduct has been going on, whether there is an opening for competition to happen. And really, it's kind of trite because now everybody's saying it, but it really does have to pry open the market. And whether it's behavioral or structural, it has to do that in order to be an effective remedy. And I think my suspicion is that that's going to lean more towards the structural than towards the behavioral.
Thank you, Caitlin. Now I turn to you, Joe. What do you think about the remedies proposal?
Thanks, Leo. I do have some thoughts here. So I want to start on the behavioral side. So first, I think a big problem with the DOJ's remedies proposal, and again, there's always some discussion whether this is just an upfront, whether they're sort of a negotiating position, but I think the search case that's ongoing makes sure we need to take this very seriously is what the DOJ thinks it can get. And what I would say first is that a lot of the conduct that they're asking Google for an injunction to stop Google from doing goes well beyond the conduct that Judge Brinkema found to be anti-competitive, right? The only two types of anti-competitive conduct that are ongoing, as far as I know, are the tying and the unified pricing rules, which Google has already agreed to say that it will stop doing. The first look and first look and last look are no longer ongoing. But again, the DOJ doesn't stop there. It has on its wish list a bunch of conduct that really involved Google leveraging its alleged power in ad networks and its AdWords tool to benefit AdX or DFP. And the interesting thing here is that that's sort of leveraging, right? And specifically the idea of Google restricting Google Ads demand to AdX. I mean, that was actually a claim that the DOJ brought and Judge Brinkema rejected. So it seems very strange to give the DOJ relief for conduct that it couldn't win on in court. I think that's the first thing to point out. The second thing to point out is another set of behavioral remedies which go along data and transparency lines. So basically forcing Google to share data and open up its ecosystem to address what John discussed. The sort of data and scale advantages, sort of as a way to make Google, so to speak, to disgorge the fruits of its statutory violation. And here I would just note that again, some of these have to do with the use of data for the advertising, the buyer tools, the ad network tools. And that was the space that Google found, that the court found Google had to monopolize, right? So it's one thing to say we want Google to, pay back the fruits of its monopoly, but that should be in the market where you found Google to have a monopoly, right? Not in the other markets. And then on the structural question, I agree with a lot of what's been said. I think there is case law that suggests that the DOJ has a right, and the court should so-called terminate the illegal monopoly. But here, Judge Brinkema, I think, was very clear in a way by finding that the DFP acquisition was not anti-competitive, and then also that the AdMeld acquisition was not anti-competitive, which was, I think she acknowledged, very important to Google's success in AdX, right? The fact that those acquisitions were not anti-competitive means that Google's monopoly, Google having monopoly power in these markets, so to speak, is not the problem in of itself, right? The problem is the conduct. So I think that counsels against a structural remedy. Kathleen is correct. There is like sort of the self-preferencing and leveraging going on here, and in theory, a structural remedy could make sense. Although I would say that behavioral remedies can also be used to address that. In the search case, for example, they have a bunch of self-preferencing restrictions that are there. But again, even if you agree with that, even if you agree that a divestiture is necessary to prevent that sort of leveraging, in theory, you should be able to only do that by forcing Google to divest one of the two products, right? Not both, right? If it got rid of either AdX or DFP, that would eliminate the sort of leveraging between the two markets that the DOJ is concerned about. They shouldn't need to divest both. So here, I really do think this is yet another example of the DOJ really stretching beyond reason the sort of remedies that I think it should be entitled to under the law, given the facts of this case.
Thank you, Joe and all. This has been a very fruitful discussion so far. Now that we are getting closer to the end of our panel, I would like to offer each speaker room for a one-sentence takeaway message. Eric, why don't we start with you?
Sure. So I'll just say, I think the two Google cases were the strongest of all these government big tech cases. And I think it's about to get, the sledding is going to get a little tougher for the agencies in the coming years.
Thank you. Caitlin?
Sure. Well, what I find heartening about both this and the Google search decision is after years of seeing in high-tech cases that judges hesitate to engage with complexity. I think in both these cases, the judges did and thoroughly analyzed the facts, and that worked to the benefit of DOJ.
Thank you, Caitlin. Joe?
Thanks, Leila. So what I would just say is this is obviously not over. Google, I think, has very strong grounds to appeal this case, just as it's going to do in the search case. And, it's not at all clear that this decision is going to stand for, I think, a lot of the reasons that were mentioned here and potentially others. I would just note again, it's important to contextualize this, as Kathleen and Eric have, with the search case that's ongoing. And basically, we now have a Department of Justice that basically across administrations is seeking to force Google to divest Chrome, Android, and now much of its ad tech ecosystem. And I really think that sends a signal about sort of the current antitrust policy. And I think folks are asking whether or not that's a good thing.
Wonderful. Thank you. And last but not least, John.
Thank you. So I'll just say very quickly that I do think the remedies are really important. It's one thing to find that, look, on net, they did maybe overstretch here or there, or these agreements are anti-competitive, but these are difficult questions. And so companies, maybe contrary to belief, I truly believe at times they don't know that this was going to ultimately be something that's harmful to competition or illicit, and they implement them in ways that probably genuinely they think this is something that works really well or can be beneficial to consumers. Maybe they know on some dimension it's harmful to competition, but that's where I think the remedy needs to be appropriate. When they sort of move into a punitive element, then you're really sort of punishing companies for behavior that I think, as long as it's calibrated, antitrust works really well. But once it becomes punitive, then it becomes a policy, and it can disincentivize certain types of innovations, because sometimes these are very difficult to discern, and these are complicated even for the companies.
Thank you, John, and to all of you, our dear esteemed panelists, for this excellent event. Now, I would like also to thank our audience for tuning in. Please continue to follow ITIF's future events. Thank you, everyone. Have a great day.